Hi, everyone, and welcome to the panel discussion on the Code of Best Practices and Fair Use for the Visual Arts. And thanks so much for coming. This session was organized, if I can give a little plug, by MCN's Intellectual Property Special Interest Group. The IPSIG is MCN's central resource for all members interested in intellectual property issues involved with information technology and museums. It's chaired by John French, Director of Visual Resources at the Yale University Art Gallery, co-chaired by me from the Yale Center for British Art. We offer a forum for discussing the intellectual property conundrums that affect the museum community, and we aim to serve as a resource for discussion, information sharing, and education for copyright, trademark, and related areas such as moral, privacy, and publicity rights. So if you are interested, please get in touch with us, join us. The College Art Association began working on the Code of Best Practices and Fair Use for the Visual Arts in 2012. The project was facilitated by Patricia Ofterheide and Peter Jaszi, professors of communication studies and law, respectively, at American University, and guided by CAA's Task Force on Fair Use. The project was funded by the Andrew W. Mellon Foundation with additional funding from the Crest Foundation. The initial phase was completed in January 2014 with the publication of Copyright, Permission, and Fair Use Among Visual Artists and the Academic and Museum Visual Arts Communities, an Issues Report. The code itself was developed through discussions with visual art professionals, including artists, art historians, educators, museum professionals, and editors, and it reflects areas where consensus exists across these communities. The final Code of Best Practices was published in February 2015. The Code of Best Practices provides visual arts professionals with a set of principles addressing best practices in the fair use of copyrighted materials. It describes how fair use can be invoked and implemented when using copyrighted materials in scholarship, teaching, museums, archives, and in the creation of art. In the panel today, our speakers will start by giving you some background on fair use in the code. How does the code differ or expand upon earlier statements or standards that museums have looked to when applying fair use to digital access to visual arts material? We'll move on to address some of the pain points for the application of code in museums and museums' digital work. And we also want to leave plenty of time for your questions and for discussion. We're circulating, well, actually, we're not circulating a sign-up sheet, but if you're interested in CAA's work in this area, you can sign up at their website for more information. And they've also kindly supplied lots of print copies of the code, and we have some at the table up here and also in the back of the room. Please take one. There should be enough for everybody. And some more about our speakers today. Peter Jaszi teaches domestic and international copyright law at American University in Washington, D.C. He also directs the Glushko Samuelson Intellectual Property Law Clinic and helped to establish the Program on Intellectual Property and Information Justice. In 1994, Professor Jaszi was a member of the Librarian of Congress's Advisory Commission on Copyright Registration and Deposit, and in 1995, he was an organizer of the Digital Future Coalition. He's a trustee of the Copyright Society of the USA and a member of the editorial board of its journal. Since 2005, Professor Jaszi has been working with Professor Ofterheide of the American University on projects designed to promote the understanding of fair use. Nancy Sims is a librarian with the University of Minnesota Libraries and subject specialist on copyright issues. She has long experience working in academic libraries and is also a lawyer who's fascinated by the pervasiveness of copyright issues in modern life. She describes her job as not to be the copyright police on campus, but rather to help individuals and groups throughout the university community understand how copyright may affect their work. Oops. Sorry about that. And let me exit here, and I will hand it over to Peter.
Well, let me just start by saying thank you very much, and thank you for having me. If you don't have a copy of the document from the chairs in the back or the table in the front, grab one, because you may want to actually glance at it a little bit while we're talking today, but more importantly, this is going to be necessarily a quick once over, and if you're interested in the content, you will then, I hope, want to look at the document at greater length. the other document referred to, if you have a copy of this document, you're lucky. It's a collector's item. There are no more hard copies, but it is, and I'll say a little bit more about it, downloadable from the CAA website. These we will continue to produce until the demand runs out, and who knows, perhaps even thereafter. So I recognize that in the room today there are people at all different levels of both sophistication and interest where copyright law principles that undergird the solutions to recurrent issues in museum practice are concerned. And so I'm going to try in the first few minutes that I have with you to very, very efficiently, perhaps it will be too efficient for some, summarize the essential copyright knowledge that I think one needs to appreciate where this project is coming from and what it may actually accomplish. And the very first piece of information we need, which is a truism but easily lost sight of, is that in the United States we only have copyright for one reason. We don't have it to make anyone rich or even to make anyone happy. We don't have it for companies. We don't have it for artists. We have it for the promotion of culture to benefit the population at large. Nothing could be clearer from the original documents of U.S. copyright and the decisions of leading courts ever since, and nothing could be sometimes in the context of current buzz around specific copyright issues easier to lose sight of. So keep that in mind because everything flows from it. Now, how do we do this? Well, there are two mechanisms in copyright law that are designed to promote the goal that I've just described. And one, of course, we're well aware of, is this mechanism of giving people who make culture limited monopolies in what they make in the hope, and it is a hope, there's no objective way of knowing whether it is true. It is an assumption rather than an evidence-based proposition, in the hope or on the assumption that by giving makers limited monopolies, we will encourage them to make and also, of course, to make available their productions. And that's great. But, of course, it poses also a threat to the objective that I've just described, because if these limited monopolies sort of grow up and become a thicket, then the next generation of makers and users, and often, especially in this digital moment, it is hard to distinguish makers from users, perhaps even useless to try. If we end up with an impenetrable copyright thicket, then contemporary makers and users are going to be discouraged from offering their new contributions, building, as all new culture does, on what went before. So, the second major proposition about copyright law and how it is designed to accomplish its constitutional cultural objective is that we build into copyright law all kinds of conditions and limitations and checks that you don't encounter where other kinds of property law, like property in chairs or property in land, are concerned. It's property while it lasts. Sometimes it lasts too long, but that's another story. It's property while it lasts, but it's a very unusual porous form of property, and those holes, those gaps, are not bugs, they're features of the copyright system. Now, I could go on at length about what all of them are, and we can later if you are interested, but I want to focus on what is arguably the most important of all of the, and I'll call these balancing features, because they're designed to get the balance between control and creation and access right. The most important of those, at least today, is the doctrine of fair use. And at the highest level of description, this doctrine, which has been around by name since the 1840s and operated under other names, but in effect even earlier than that, this old, venerable doctrine, at the highest level of description, is simply a doctrine that says that sometimes the social, the cultural, or even the economic utility of an unauthorized use may be significant enough in relation to the interests of the rights holder so that that unauthorized use should be considered a non-infringing use. A fair use is not an infringement. It isn't a privileged infringement. It isn't an excused infringement. It isn't anything of the kind. It is a non-infringing use. And we know, we didn't know this originally, but recent court decisions at the very highest level have retrofitted a rationale, an additional rationale, we might say, to this doctrine. And we know from the last 20 years of Supreme Court decisions that the fair use doctrine is grounded in First Amendment principles of freedom of expression, and the court has in fact gone so far as to suggest that if we didn't have a fair use principle, we would be looking at a conflict, a impending crash between two valued, constitutionally grounded aspects of federal law. That's an important thing to remember as we go along, because this understanding of fair use and its First Amendment connections has contributed a lot to the new ways in which courts have been understanding fair use doctrines, or the details of fair use doctrine, in recent time. Here are a few other propositions about fair use, which I have drawn primarily from Q&As that I have encountered in other versions of this talk with other audiences. Sometimes at the very end, I'm very proud of myself and I think I've explained everything very well, and then someone pipes up and says, how do I get a license to make fair use? And I know I've done something wrong, because the proposition is that if it's a fair use, it's not an infringement. If it's not an infringement, or a potential infringement, you don't need a license. You're as entitled to make that use as you are any other use. And then there's this statement, which is true, but has a sort of a sting in its tail, that fair use is very contextual, that it's circumstantial, that it depends on all the facts and surrounding conditions. Sometimes that statement is used to denigrate fair use. And you will hear people say, oh, well, you just can't rely on fair use because it's all contextual and every case is different from every other case. The project I'm going to describe to you in a moment is directly addressed to that specious argument. But this same proposition, it's all contextual, is also potentially very helpful, because if we absorb it and internalize it, it should help us to understand why we can't rely on many of the articulations of fair use doctrine that have been created over the last, say, 35 years to help different communities understand better how to apply fair use. It isn't amenable to guidelines with fixed metrics in terms of inches or pixels or durations or any other tool of measurement you might describe. They simply don't work as a way of trying to catch this particular lightning bolt in a bottle. And we should be extremely cautious, which is to say we should run fast in the other direction when anyone offers us fair use solutions that involve metrics or rules of thumb or checklists. They're always misleading, and usually, not always, but usually, they have the effect of selling our fair use rights short. And yes, in case anyone should ever question that proposition for you or with you or to you, fair use is a right, and we know that not only because it is expressly related to the First Amendment right of free expression, but also because the Congress itself has chosen to call it a right in the copyright statute when fair use was first incorporated literally into the statute law in the 1976 legislation. So it's a right, and like other rights, this is an extremely useful proposition, I think, you don't have to exercise it. You can choose, in appropriate circumstances, not to exercise your fair use rights. So if you want to use a work, the copyright in which belongs to somebody who's a longtime friend or professional associate or someone whose goodwill is valuable to you, you may forego fair use, especially if that nice friend is willing to give you a clean, inexpensive, useful license. And you don't have to be consistent in your exercise of fair use. A scholar who's writing a book full of images may choose, for reasons like those that I've just described or others, to license a few and to rely on fair use for the others. And no one is going to be able to attack that scholar and say, oh, but because you've licensed one image, you should have behaved consistently and licensed other images of the same kind for similar purposes. There is no rule of consistency in fair use, and it's an important thing to remember. My late father, are there any Hegelians in the room? Well, my late father was a sort of an amateur Hegelian, and he always claimed that somewhere in the aphorisms of Hegel there was a statement that, as he quoted it in translation, of course, that consistency is the virtue of cattle. I have asked many Hegelians about this. So far, we haven't found it. I'm beginning to think that perhaps my father made it up. I don't know how I feel about that, but it's worth remembering whoever's statement it is. Okay, now let's get a little more granular about fair use. Let's get as granular, in fact, as the 1976 Copyright Act did when it codified, to use a nice legal term, which simply means writing down in the law something that judges previously have invented and been in charge of, when it codified fair use. They said, when you're considering whether a given use is a fair non-infringing use, there are at least four things you need to think about. You could think about others, too. It's not an exclusive list. And we're not saying how much or how little. You should think about them because the statute doesn't say anything about rank ordering or priority. But you should think about these four things. You should think about, and by the way, this thinking I'm describing goes on at all sorts of different stages. An individual who's planning an exhibit or an online presentation of collection material thinks about this, or should, or could, in advance of undertaking that project. A grant applicant who knows that funders like digitization projects that provide for public access to the material digitized thinks about these questions in deciding whether, as part of the grant, they can propose that all of the digitized material, some of which may be covered by copyright, will be put online, and so on and so forth. Users or makers, depending on your point of view, think about these factors before they act. And sometimes so-called gatekeepers think about these factors when they decide whether or not to let the users proceed. Who's a gatekeeper? Well, it could be, wouldn't be Nancy, of course, but it could be somebody who is the copyright police in your institution. That could be a lawyer, it could be a non-lawyer. It could even sometimes, I'm ashamed to say, I've seen such institutions be an IT person who has gotten the copyright police cudgel as part of his or her set of tools of employment and is doing his or her best to wield it. And in other contexts, gatekeepers could be extra-institutional. A funder could be a gatekeeper. Sometimes funders want to know whether or not you can really, consistent with law, do the things in terms of providing public access that you're representing in your grant application you will do. Could be a publisher where publishers are involved. Sometimes it can be, and this may not apply so much here, but it certainly does in other domains of practice, an insurance company, and so on and so forth. Well, in deciding to whether let a given user proceed in exercising their institutional or extra-institutional authority, gatekeepers think about these four things. And then, of course, in the world of the law, when a judge has to decide a fair use case, he or she thinks about these things in coming to a conclusion. So these are what the statute offers us as things to think about wherever in the, if I can coin this phrase, wherever in the fair use system they may be situated. I should add here that in the 10 years that the project that I am describing to you has been going on, we've never actually gotten to that final audience. Different communities of practice, some of which I'll describe or at least name to you in a moment, have been working with codes of best practices of this kind, or best practices of this kind for a decade in increasing numbers. There are 12 or 13 of these out in the world right now. And no one, this is an important proposition, no one operating within the framework of one of these codes of best practices has ever been sued for copyright infringement. I don't mean has ever been sued and lost. I mean, has ever been sued for copyright infringement. Some of us in the project sort of look forward to the day, no, we don't, but when we've had a few drinks, we regret the fact that there have been no lawsuits because we're anxious to see, we believe, strongly believe, that if and when somebody operating within the four corners of one of these codes of best practices were sued, the code would operate very much to their advantage in the judicial consideration of the case. But so far, the codes have seemed to act as sort of, wolf's bane to rights holders, at least to the extent that none of them has chosen to find an opportunity to challenge any activities that take place pursuant to them. Now, this is great, but it's still a little, what does it mean? And from, I would say, 1976 to 1990 or so, there was a lot of sort of grumping about fair use, especially, and I have to acknowledge this, I don't think I was one of them, but I certainly was part of the same class among academics with too much ham in their hands. There was a certain amount of grumping about fair use and how it didn't really make sense, and it wasn't predictable, and it wasn't reliable, and it wasn't robust, and who knows, Judge Easterbrook of the Seventh Circuit went so far as to refer to those as the four fuzzball factors of fair use. That kind of thing. And I think to some extent, over time, the courts got the message that they had to clean this up a little bit and produce a simpler, a more predictable, a more rooted, that is, by reference to actual practice, way of describing and then applying the fair use doctrine. And what they came up with, and by they I mean different courts, and then ultimately around 1994, the Supreme Court, and since then many more courts, what they've come up with is what amounts to a kind of a two-step test that operates in domains like the ones that you are engaged in. That is, domains in which the reuse of copyrighted materials fulfills some kind of educational or cultural or other significant new cultural purpose. Two questions. First, is the use transformative, which means pretty simply, is what the user is doing with the work substantially different from what the work was originally designed to be used for? So a classic example from the domain of documentary filmmaking, documentary filmmakers having been the first practice community to actually come together and generate one of these codes of best practices. A classic example, which you see in documentary films all the time, is the situation where somebody the film has a protagonist, and the protagonist has gone into a bar or a restaurant, and there's a radio playing a popular song or a television showing a sports game in the background. Used to be, once upon a time in the bad old days, that documentary filmmakers would pay thousands upon thousands upon thousands of dollars to license those brief media artifacts so that they could actually represent truthfully in their films what was actually going on. Not anymore, because it's an obvious example of fair use. What the filmmaker is doing, that is portraying the activities of the protagonist in a specific social and perhaps cultural context, is entirely different from what the original provider of that sports game or that song had in mind when it addressed its natural audience, a transformative use. And then if the use is transformative, the second question is the amount of material used appropriate to the use? So if in my documentary hypothetical, the game got really interesting and everyone in the room paused and watched the game for 15 minutes, and the filmmaker faithfully recorded every bit of action on the screen during those 15 minutes, we might question, not with a certain answer, but question whether or not the material was still being used in an appropriate or reasonable amount. But a few seconds, a minute, whatever it may be, the case is obvious and the answer is clear and the use is fair. Now, this is a formula which is obviously not self-explanatory, but which lends itself to repeated application in court in a wide variety of different cases, fortunately very few, if any, of them relating to the kinds of cultural institutions that you represent. But from those cases, which may involve the entertainment industry or book publishing or a variety of other activities, we learn things about fair use. And one of the things that we've learned most recently, of course, is that the activities that the research libraries and Google undertook in digitizing, well, there's an argument. Some say 12 million, some say 15 million. It's not clear. Are you counting unique titles? But a lot of books for a variety of purposes, including search and non-consumptive research and the making material accessible to the blind, that those were legitimate fair use activities. Millions and millions and millions of books. And we know that from the two Second Circuit cases, Hathi Trust of last year and now very recently Google Books of this year. So we get a lot of information. It's not directly applicable, but it's important from this material. Now, when judges, and the insight I'm going to describe here is not original to me, it's not original to our project, and whenever I describe it, I give credit because attribution is very important. This is an insight that is owed to Professor Mike Madison at the University of Pittsburgh, who wrote in about 2005 a seminal article on all of this stuff. He was the first person, not the last, but the first person actually to sit down bless his heart, I wouldn't have been able to do it, and read all the fair use cases decided from the earliest times down to what was then the present day, and look for patterns. And one of the patterns Mike found is a very important one, which is that when judges don't know what to do, when they're confronted with a new problem, when they're confronted with a fair use issue as to which there isn't a long judicial record of past cases, they look out for information, and in particular, they look to the fields of practice in which the use took place, and they ask the question, is this a legitimate example of whatever people in that field of practice do in furtherance of their cultural mission, for lack of a better term, or is this let's see, what would one say? Let's say a hypocritical instance or invocation of fair use. And so it is from that insight that this idea of creating best practices codes that I'm going to describe now very, very quickly arose. Before I do it, though, based on something that I think I heard while I was standing in the back of the room listening to the tail end of the last session, in which some of you I know took part, there's one other proposition. It's not a proposition exactly about fair use, a proposition about copyright law that I think is important to emphasize. And it has a relevance to fair use, which I'll describe to you in a moment. There is, and I know this from 10 years of wandering around talking to different practice communities about their issues and concerns, there is a real seated belief in many practice communities, and especially among cultural institutions, that although they may do something for a good and lawful reason, the exercise of fair use, for example, they have legal responsibility for possible downstream misuses of objects that they have made available to others, that they are responsible. So, let's take a well, maybe it's not such a silly example. You make a relatively high resolution image of a copyrighted object from a museum collection available online, as the policy that we'll talk about in a moment clearly states you are entitled to do under certain conditions as fair use. And somebody comes to your site and they think, that's great, I like that image, I'm going to take that and make a shower curtain. And they do. And you don't need such a high resolution image to make a decent shower curtain. It's a nice shower curtain. It's a nice enough shower curtain. And it's also not necessarily a fair use, because the picture, original purpose of the picture, was at least in part a decorative one, and the purpose of the image on the shower curtain is a decorative one. It's not a very transformative use of an image. Well, institutions are scared that they'll be left with deep pockets holding the bag for that fly-by-night shower curtain producer who perhaps can't ever actually be found, or if found, can't be brought to account, or if brought to account, turns out not to have any money. And that's simply not true. And this has nothing to do with fair use now. It is a basic proposition of copyright law, again, sanctioned and reinforced by recent Supreme Court case law, that the legitimate provider of material isn't liable for its misuse by others. In order to be liable for such misuse, you have to be actively involved in it in some way. You'd have to be posting that on your website with a label that says, nudge, nudge, suitable for shower curtains, which you're obviously not doing. So this is an overstated, I might even say massively overstated institutional concern, which holds back or constrains the exercise of fair use pursuant to documents like the one I'm about to describe to you, and it's vaporware. It's nothing. It's not true. And that doesn't mean it isn't powerful, because many false ideas are powerful. But this is a false idea. Now, end of digression. From the insight of Professor Madison's that I described a moment ago, Pat Aufderheide and I and others who've been involved in this Code of Best Practices, Fair Use Code of Best Practices initiative from the beginning, got our big idea. And our big idea was that maybe it would be possible to get people in different fields of practice, fields that have at least some unity and integrity, to come together to talk with each other, to hammer out questions about when a particular mission-related use is or isn't fair, and then to publicize the results, both within the community and beyond the community, that they arrive at. And that's what we've been doing for the last 10 years, and we've been doing it, as I said a moment ago, with lots of different groups. Started with documentary filmmakers, and there have been scholarly societies and dance archivists and poets and research libraries and open courseware providers, and I'm sure I'm leaving out some of the most important ones, but you get the idea. And again, a point I made earlier that I want to reiterate, the end result of these processes is not like other guidance documents on fair use that you've seen. These documents aim, and I think to some extent succeed, in describing a way of reasoning through fair use issues to a robust result, rather than a formula that can be unmindfully applied to produce a less than robust result. They're based on professional consensus within communities, and they are not, repeat, not negotiated with copyright holders. So in the sessions that led up to the CAA Visual Arts Code of Best Practices that you have copies of and that we'll be talking about further, there were all kinds of people in the room. There were curators, there were scholars, there were working artists, a lot of them. We found it was very important to include them. There were gallerists, there were publishers, there were bloggers, but you didn't find ARS and VAGA in those rooms. We talked to them, in fact, at length in an earlier stage of the study to find out what their views and positions are, but the methodology of these best practices codes is not to negotiate best practices, or I should say fair use guidelines, between those who are rights holders and rights holders only, and those who are user makers and user maker only. That formula has been tried again and again and again since 1976. The results have been systematically, unconditionally useless. And so we have had no desire to reproduce those exercises in futility. Any of this stuff, by the way, that I'm spouting about fair use and law now, should any of it be at all interesting, in the blue document, there's a little sort of an afterword, I guess it's technically an appendix that I wrote that summarizes a lot of this stuff, but I'm not going to belabor it further. I'm going to talk now about the code and how it worked. Stage 1, first year, fact-finding, 100+ long-form interviews with opinion leaders in the field. trying to ascertain what the problems were, where visual arts practice in any and all of its forms came up against copyright, where copyright seemed to be an impediment to the fulfillment of mission. And then, once this report had been published and widely discussed, a series of focus groups around the country with this mixed character, all kinds of people from within the visual arts field in every focus group that I described a moment ago, designed to build consensus around mainstream, middle of the road, agreed upon norms in the professional employment of fair use. These aren't wild-eyed, radical propositions by any means, nor is the document entirely comprehensive. There were some issues about which consensus wasn't available. We're very clear in the document about what they were. Nor, of course, is the document exhaustive. There's plenty of potential room for fair use that doesn't fall literally within the safe zones defined in the code. But those safe zones are turning out to be useful nevertheless. So, we distilled this information from these meetings, and then we did various things with it. We took it to the committee structure of the CAA, which is pretty elaborate, and got a lot of very good input from the various committee members. And then finally, we took it to 5 very, very well-informed copyright lawyers, 2 working within museums, 2 in private practice, 1 academic, and asked them whether it made sense, whether what we, listening to these small groups, had heard the community say about norms in fair use was within the framework established by the statute and the decisions under it. There are so few cases that we couldn't ask the experts whether everything that the groups had come up with was literally supported by a specific case, because the answer would, of course, be no. We asked them instead, is the projection of fair use doctrine into zones where courts have never traveled, that these community members have undertaken, a plausible one which would be likely to earn respect were it ever presented to a court? And that's the question to which, with some questions which were then addressed and written into the document itself, they all eventually responded yes. So this is the issues report that I mentioned. If you look at it, you'll notice that there were problems, that the people we talked to in the first year did report significant deformation of their professional practice by copyright concerns. And this slide summarizes what I've said before about the nature of the people who got together in these 10 long 4-hour discussion groups to hash out consensus solutions, all kinds of people. And of course, although entities that functioned exclusively as rights holders weren't in the rooms, there were lots of people in the rooms who were themselves rights holders, especially the visual artists who were prominent in every room. And often these discussions would reach a point at which someone would say, well, how do those of you who own rights and whose rights are valuable to you feel about having the emergent norm that this room has been moving toward applied to your own stuff? And that would sometimes lead to other discussions and then eventually to the final conclusions which were arrived at. Now, as has already been suggested, there are 5 principles in the Code of Best Practices, 5 recurrent situations where copyright was a problem that are described in the original document, are covered here, writing about art, teaching about art, making art, museum uses, and a related but distinct question, uses in or related or concerned with online archives that may or may not be museum-based. In each case, the code states the principle, the broad principle of the applicability of fair use in this situation. Well, now let me go back a little. If you pick up the document and you look at any one of the substantive sections of the document, which you'll find beginning about midway, it might be page 14 or page 11, I can't remember. Anyway, what you'll see is the first thing you'll see is a description. The description is very important because it's the scope note. It describes the range of problems addressed and hence the range of applicability of the principle. The second thing you'll find in each statement, in each section, is a short statement of the principle. In general, fair use applies to museum uses of the kind described above, subject to the following limitations. And the third, and arguably the most important of the recurrent sections of each of the subject matter related pieces of the code, is that set of limitations. The things that members of the community felt professionals needed to do when making fair use to present the best professional, ethical, and legal defense for their activities. And we're going to talk later about what's in some of those principles. So I'm going to in some of those sections of the code, description, principle, limitations. So I'll leave that, and right now it's your chance to hear from others.
It's the right thing. Whoa. No, the connection's fine. It's just, we just need to change this. Yep, that's not a problem. So, I'm gonna skip through some of this. I'm basically here because I spend a lot of time consulting with individuals about their fair use issues within the University of Minnesota and outside, cultural organizations in Minnesota and across the country. And what I'm talking about here is kind of the choke points when people are trying to apply fair use in institutional contexts, the choke points, some of which are addressed by the code. And Peter already hit some of these. So one of the things that a lot of people have trouble with fair use is they feel, oh, it's uncertain. My visual metaphor for this is, oh, we are being forced to consume Jell-O, stand on Jell-O. I don't like Jell-O, it's very wiggly. Peter has actually seen this before at a previous discussion. So I don't love Jell-O, but this is definitely not Jell-O, and it's definitely not something I want to eat. So one thing that I try to help people think about with respect to fair use, and that I think these codes of best practices do very well. You're gonna full screen? Yes, that works. There we go. One of the things that I think the codes of best practices do very well is to help you understand the scope of the jello, see where it's wiggling, see where other people are dealing with the wiggles, without doing this thing that a lot of the previous documents have done, in particular the sort of the 1980s and 90s documents about fair use tried to give us, yes, this, no, that, definitely not this, and that is undermining the basic purpose of fair use. So just one thing that the codes do very well is help you see the lay of the land, especially to see the lay of the land in your field of practice. What are other people doing? What has seemed reasonable in this field of practice? Because one of the challenges with fair use is that one of the reasons it feels so uncertain to people is you don't always know the answer to, is this a fair use, until somebody decides to take something to court. And if nobody's ever done something quite like what you're doing, well, nobody's ever gone to court, so we don't know the answer. Well, if you want answers, you don't want fair use. And as Peter also said, fair use is really a very important part of copyright law. It enshrines lots of important First Amendment values. So one point where lots of people get bogged down trying to apply fair use in institutional contexts is this uncertainty. I would like to get people to flip their minds around. Uncertainty, yeah, there's uncertainty with fair use, but it's flexibility. The flexibility and the uncertainty are the same thing, and fair use exists in order to provide that flex in our law. And I think these codes do a very good job of helping you see the scope of the flex in your own field. And also when you have the opportunity to talk with people in your field about their, how they're thinking through these codes and how they're applying them in their practice, that can also help you embrace the flexibility. We definitely don't want fair use like that. One other thing that I think these documents do very well that I don't always bring up. A lot of the audiences I talk to are people who are afraid to exercise their fair use rights. But I also know that there are some technologists in the room, and technologists are not people who tend to be afraid to exercise their fair use rights, at least in their home lives, in their personal lives. There's a lot of people in the technology world who like to leap before they look. And one of the things that I think the codes do very well in those situations is give people who are prone to going, well, we've got the tech to do it, so let's just do it. Give them a view of the situation. If you're going to be diving headfirst, we've got the tech, so let's just go do whatever the tech lets us do. The codes give you an opportunity to look at how other people are approaching similar kinds of situations, or to reason from previous applications of technologies so that when there's new things that come up, you have a little bit of a view before you step off into undefined space. The last thing that I wanted to bring up as far as choke points, and again, Peter has referred to this at least a little bit, there are people in the cultural organization world, in IT, in libraries, who like their function of being the cops. I actually was overestimating how many people there are like this for a long time, because there are also people in all of these worlds who act as cops because they feel that it's a good service to provide to the user community. It took me a long time to understand that my fellow librarians at Minnesota, they were always pushing me to tell them what they could tell faculty was fair use or not. And I kept saying, we can't. You know, the faculty member knows best and all of this. The librarians want to give answers on that, and I know that lots of people in some, in education and outreach positions in the museum world maybe, want to give answers to users. Yes, you can do this. No, you can't do that, because they see that as a service, because they see that as helping the users from getting into trouble, all of those kinds of things. But those are not the people I'm really talking about here today. There are the people in the cultural organization world who really like to be the copyright police. And they will bring up things, again, this is something Peter made reference to, he was saying this is non-infringing use. They will bring up fair use is only a defense to copyright infringement. Fair use is kind of a sneaky thing. I should say about the defense thing, it is technically true that sometimes you raise fair use procedurally as a defense. That is not the only time fair use comes up in court situations. It used to be the most common time. It is really not the most common time at all anymore. So if anybody ever tells you this, send them to talk to me. I will tell them all about motions for summary judgment and all kinds of great things where fair use comes up where it's not a defense. But a lot of people who have this police mindset see the application of fair use as a sneaky thing, as a shady thing. we saw this when I opened this, as perhaps downright unethical. And that's something I actually don't know, and I know that this conference is pulling from a couple of different threads of museum worlds. I don't know if there are articulated principles of ethics in your worlds. The library world has some articulated ethical principles that I think really hit this point very well. And one of those goals, one of those articulated points in the ALA Code of Ethics is we do not put the interests of commercial actors ahead of those of our users. That is an articulated ethical point within the professional standards. I don't know if there are points that are quite that solidly on this whole fair use is for users, fair use accomplishes public goals. In museum worlds, I don't know if there are differences between art museums and natural history museums and that sort of thing, but that may be a conversation to be having with your colleagues in other museum world contexts. Is this an ethical violation, or is this perhaps serving some of the highest ethics of the profession? And as we said at the very beginning of all of this, achieving the real goal of copyright, which is to spread culture and to spread knowledge. And copyright is a public interest law. So that's really the full extent of what I have here.
Great. Would you like me very quickly just to walk through the museum uses principle?
Maybe very quickly, and we'll try and take a couple questions before we zoom off for lunch.
We have 5 minutes left before.
Oh, well, then not. Let's.
Are there any questions from the audience for our panelists? And, John will bring you the microphone.
The session closes on open access. And I just wanted to ask, copyright, the only black and white thing in copyright seems to be copyright or public domain. Everything else is a little kind of ambiguous in between. And the way that museums have been rolling out open access seems to be a little different institution to institution. And of course, open access is not a legal term. And some people in the publishing industry are not comfortable using open access images because they're not quite sure what they are and if they remain open access and where they stand legally using something. So can you tell me, define what that means, open access, from a legal standpoint?
Nancy?
It doesn't mean anything from a legal standpoint. It's not a legally defined term. I can tell you from the first group that really started using open access to mean something consistently would be the groups that came up with the Budapest open access definitions. The Budapest definition is oriented to academic publications, but I think highly relevant to museums sharing their works online. And the Budapest definition includes that the works be freely available, be accessible without charge, and that they be free of restrictions on reuse. Under a Budapest definition, a work that is merely freely accessible is not open access. I would say certainly in the academic publishing world, the more dominant model of open access is just anything that you can get to freely online. But for publishers, obviously, the only, if they're going to be using someone else's work in a new publication, something that anyone can get to is not the same thing for a publisher as something that has clear reuse rights.
So let me follow up and relate the very good question and that excellent answer to the code for a moment, because there are really two pieces of the code that relate to the complex problem that you've described. There is the principle on museum uses, which makes it very clear that subject to a set of articulated limitations that you can read, museums can make available online downloadable images of material in their collections, including copyrighted material. That's a very, very important premise of the code. So you could say that a downloadable image of a copyrighted work in the museum collection made available online was a kind of an open access image in the sense that anyone might come to it, consult it, and use it for a variety of different purposes. Now, let's assume that the use of that is a use by a publisher or by an author whose publisher has to make decisions in its gatekeeper role about what images will and will not be included without license. That situation is addressed in another part of the code, which is the part that we have titled Writing About Art. And that part of the code is, again, very clear. And again, I'm not stating a personal opinion here. I'm stating the consensus view of an extremely broad representation of the visual arts field as a whole. That section of the code is very clear for the proposition that relevant illustrations in scholarly publications, both journal publications and monograph publications, and for that matter, other kinds of publications that spring up in the digital environment as well, that such illustrative use is subject to a few exceptions, a few limitations, like attribution and so forth, is a core example of fair use. So if you take those two related principles of the code together, they describe a zone of use that involves museums making available on the one hand and authors and publishers taking advantage on the other hand, which is, according to the consensus view of the visual arts field, squarely within the sweet spot of fair use as it is now understood. And we have the field and the various editors and lawyers and all who worked on this document as our backup for that proposition. Doesn't give us so I think that sometimes it's helpful to take a big concept like open access, which can mean so many things, and to break it down functionally and to say, well, what are people trying to accomplish by taking advantage of or proposing this example of open access? And in this case, one of the things that museums and scholars and museums and teachers and museums and students cooperate in facilitating is a broader use of relatively high quality representative images of important works of art in a wide range of cultural settings, educational, scholarly, and also sort of academic in the higher ed sense. I don't know if that's helpful, but that if I were to filter the question through the code, that's the answer that I would give.
Would it make sense that people apply the CC license, because some museums apply the CC license 0?
Well, the thing is that if I've got a contemporary work of art in my museum, I can, I suppose, apply a CC license, but I can't bind the copyright owner of the image by my license. No one really should need a CC license for my documentation of the image, if it's two-dimensional, under Bridgman against Corel, and I can't really give a CC license with respect to that particular Picasso, for example, because I don't own it. So one of the problems with CC licenses is that you have to be quite specific about what it is that you're giving away, and you have to be careful not to be seen as giving away things that you don't own. One of the beauties of fair use, as I was trying to explain earlier, is that it does not require a license, doesn't require a specific license, and it doesn't require a CC license. Fair use and CC, I think, are sort of yin and yang. They complement each other, they cover different territories, they relatively seldom intersect.
Just very briefly, there's one where you do have the ability to grant a clear license. I'm very anti museums putting CC licenses on accurate reproductions of two-dimensional works. I don't think museums should be claiming rights in those works. But where there's a work that is owned by the museum,
Yes.
where there is an opportunity to work with a rights holder to get them to give you permission to put Creative Commons license on things, one factor where Creative Commons can do something that fair use cannot is to enable international use. And fair use there are more countries that are seeing the value of fair use, and I'm really hoping that there will be more spread of it, but at the same time, there's some international agreements that aren't looking really too cheery for the spread of fair use. But that's one reason why we work with metadata, for example, produced at the University of Minnesota. We don't believe there's actually a copyright in most of that, but we're going to put a CC0 on it so that international users in jurisdictions where there is a right of some kind in data will know that they can use it too. So that's one thing that the CC licenses have a positive effect, but at the same time, there's some really important things that fair use accomplishes that CC can't. So.
Well said.
Where the code explains that it is fair use to use an image for scholarly publication, does the code distinguish between what is scholarly, what is commercial, and perhaps what is a textbook?
All right. So let's go to the first question is a really important one. One of the great and important facts about fair use is that it doesn't make a significant, in its present form, in the form in which it's emerged over the last 25 years in the courts, it does not make a significant distinction between commercial and non-commercial. So the commercial consideration should and does for purposes of this document drop out substantially of this domain. So the code does not make a scholarly versus commercial distinction because no such distinction exists in the law. So then you get to the other question of, in other words, that monograph probably will run a loss, but it could sell a bunch of copies. It could become popular, and it makes absolutely no difference from a fair use standpoint, whether it's a moneymaker or a money loser. And it makes, if you think about fair use jurisprudence, almost all the decided cases, for obvious reasons, are cases in which the defendants invoking fair use have been large commercial enterprises. You don't get much larger than Google. So that is a non-distinction. The distinction between scholarly and textbooks is I think, treated by implication in the code rather than directly. And so the question is going to be a question of the purpose of the use and whether or not it has, in effect, a discursive purpose. I don't think one can make a categorical statement, textbook versus scholarly work, a book that is, in effect, simply designed to display a sort of eligible examples of work from a given period is probably not a discursive use. And a textbook which compares and contrasts and enters into an engagement with illustrated work is as scholarly as a monograph. The thing about this code, and I want to reiterate it, and it's why I hope that those of you who've come today and may have any interest in it will actually read it and look at the extensive online materials that are available at the College Art Association website, including lots and lots of Q&A relating to it. The code is really not designed to erect and then defend these bright line distinctions, but rather to say again, to provide a pretty reasonable, let's say an accessible way of thinking through these questions to a conclusion that will be robust and defensible. Not every textbook is made alike, in other words.
So So I think actually, unfortunately, we'll have to end here. I know some of us are expected at the SIG luncheon, but hopefully Peter and Nancy could maybe stick around to answer a couple more
Happy to.
questions for anyone that's not heading off. And thank you so much to both of you for coming and for all of you for
Pleasure.
coming. Thank you.
I met you in New York when you did the talk.
Which
on
one?
This code of best practices at NIFA.
Oh, yeah, of
Yeah,
course,
and
of
I
course.
spoke to Janet, and we're going to have either you, I think it's Patricia's going to speak at FIT. We're having a joint meeting. of
That's the SUNY. Yeah, I was so sorry. I wanted to come, but I just have an absolute fixed conflict for the date, and I know it's a
Yeah.
unique date.
That's all right. But I did a after I sat in on your session at NIFA, I did a webinar that AAM put online
Oh, great.
about copyright issues, and they had a lawyer present that was part of the Q&A, and he stated fair use as a defense. I was
in
like,
response to
are
your
you
know, it's
kidding me?
just,
Deb's question in the previous session.
you know, I could go
And it's
on
like,
and on
and
about,
that's part of
I
our
could,
community
I
here.
could go on and on about lawyers. It's something that I usually don't do because it doesn't seem to be in good taste. But
Because I do that from time to time, like I'm the person who says.
It was
this,
frustrating.
let me just say it this way.
Yeah.
What would you say,
No information about
how old is this?
Do you want to?
I don't think he was that old. Yeah.
Oh, then that's not an excuse, because there is a generational thing.
Right.
In other words, lawyers who don't keep up, don't know all of this stuff.
Right.
But it doesn't sound like that's the excuse. No, I mean, that's just part of the in terrorem, anti-fair use, don't ever do anything without talking to your lawyer. I'm the one who knows, and you're just an idiot,
I was a little frustrated
idiot
that
curator.
they would talk about this publication. Like
I would be a little
asked it-
frustrated,
I
too.
asked about it in the chat session underneath
Yeah.
the webinar, and I was a little frustrated.
This was an
That's
AAM webinar. Let me
Well,
find
you know,
it.
the museum.
I bet I do
has
this
a
out.
similar guide.
Yeah.
You're probably familiar with it, the AMD, the American.
Oh, I know the organization.
We have also have a code, a guide,
More restrictive.
a guideline on fair use.
Yeah.
Well, the thumbnail document.
Yeah.
Yeah, and that was a great document 5 years ago. And it's not a great document now, and I think the leadership knows it.
Yeah. Let me ask you a question, because we talked about like not being responsible for downstream
Yes.
infringement, right? But what about in this case? And this is a common practice in the museum. It's not just people coming and getting.
You mean the website
It's
for?
us actually giving it to them.
When you say giving it, what do you mean?
Like someone calls and says, "I want this high resolution image of this Rauschenberg in your collection."
And what do they say it's for?
They say it's for a publication.
And you ask any further question?
We say to them, "It's your responsibility to use it."
You're fine.
If you have to rely on fair use to make the thing available, you probably don't have enough rights to grant a Creative Commons license. We actually have this like really concrete problems along those lines. We had a grant to do digitization of audio interviews recorded, like oral histories. We have tons of oral histories.
So I'm not sure. Say what the problem
Many of
is.
which don't have great documentation, but oral histories actually are a recent enough thing. They often have like some kind of a forum of people sign this. But we determined we didn't have that.
Right. Of course.
They have pretty clear
There
guidelines
were
on
a whole
copyright
bunch.
issues.
We could find digitizing the fair use. It's like we were sure there was no problematic rights.
Yes, no, that's very good. Now I understand. And the answer is simple, and that is that you have no more
And there were a whole bunch.
liability for that rogue user of ArtStore than you would have for a rogue user with whom you dealt directly. The only situation that might change is if one knew that there was large-scale, systematic, ongoing violations of ArtStore's agreement